That's not a change. It's residential.
Okay. I'd like to call the January 6, 2026, 6 p.m. Planning and Zoning meeting to order. Welcome, everyone. First, we'll start with the roll call. Starting on my left, Commissioner Craig.
Here.
Commissioner Nelson.
Here.
Commissioner Lauer.
Here.
Commissioner Lofty. Commissioner Stanley.
Here.
Commissioner Brown.
Here.
Commissioner Pluta.
Here.
Thank you. Okay, if we could then start the brand new year with a moment of silence. Okay, thank you. We'll move on to the agenda. Do we have an adoption of the agenda as presented? Or do we have any additions?
I'd like to suggest 2 additions,
Okay,
one of which is to add the elections of officers for 2026,
okay,
which is supposed to occur in January. And the second one is a short update, perhaps at the end, by the planning director on the Hearn building and the building next to it, which I got some glimpse of. I think the council considered some of this, but so I'd just like to find out what's going on. And in as much as we approved the site plan for this stuff probably over a year ago, to see what the issue is, which involved, of course, raising the building that was next to it and incorporating that in the number of units. So just kind of update so we know what's going on.
okay. Do we have any other additions? Anyone? I would like to add, if we could have a quick update at the end, very brief, regarding the non-conforming lot of 611 Hubert that we discussed at the end of the December meeting. And the last thing, I'd like to make a change that the minutes that were submitted should be for December as opposed to January.
Yep.
Okay, so any deletions? All right, no other additions? Do we have a motion to accept with the additions?
So moved.
Do we have a second?
Second.
Okay, all in favor?
Aye.
Anyone opposed? No. Great. Okay, approval of the minutes for December. I forgot to check that date. Was that the 6th of December? I know it was December, not January.
Yes, wasn't it?
Maybe.
Anybody got a calendar?
Yeah, I do. I'm looking at it now.
It was the 2nd, I think.
It was December 2nd.
Okay.
November.
No, it'd be December, wasn't it?
Oh, correct.
Yes, December.
Yeah, December 2nd, 2025. Okay, do we have any other additions or deletions to the minutes? No? Okay, do we have a motion to accept this presented with just the date change?
I'll make a motion.
Okay, thank you.
Second.
Second, all in favor?
Aye.
Anyone opposed?
Abstained, so it wasn't here.
Okay, good. Okay, so then I think we would move to elections.
We can do that.
Ready? I make a motion that we, I want to nominate Mr. Brown
As,
as chair.
okay.
Second.
Do we vote or do we go with the vice first as well?
You can do it.
Do it individually.
Okay,
Yeah,
individually.
individually.
Okay, do we have any comments? Okay, would that be acceptable, Mr. Brown?
That'd be fine.
Okay, all right, we'll go to a vote. All in favor?
Aye.
Anyone opposed? Okay, excellent. Okay, now we'll move to the vice chair.
I make a motion for Matt
Commissioner
for
Pluto,
vice chair.
vice chair. Okay, I'll second that. Do we have any comments? Would that be acceptable to you?
Yep. Sure.
Any comments?
George,
Sure.
Okay, let's move this to a vote. All in favor?
Aye.
Anyone opposed? Okay, congratulations. I guess we'll turn this over to Mr. Brown.
Oh, my goodness.
right to it.
Okay.
Congratulations.
Well, thank you.
Congratulations, guys.
Thank you.
Thank you.
All right, well, let's go to the agenda. Any old business? I don't think so. All right, let's go to new business. The first item on the agenda is PZSC 26-0001, the Damian Folks at 506 South Regulator Drive. It's coming from, I believe, the Board of Appeals, and there's a recommendation to the Board of Appeals for an intermediate care facility land use. The land use is classified as a special exception in the residential zoning district. It's an optional public hearing. I believe there are people here to testify, so we're going to have a public hearing. And so do you want, I have a procedural question first.
Yeah, I just want, so this has not gone to the Board of Appeals yet. It goes at the end of the month. You make a recommendation to the Board of Appeals, and then they actually make the decision at the end of the month.
So I have a procedural question on that. I don't believe everything that's going to the Board of Appeals comes to us for a recommendation. Is that correct?
Not everything, no.
So what's the criteria for this to be in front of us now? In other words, why is this in front of us as opposed to something else in front of the Board of Appeals?
Yeah, there's an item in our code that, like, in the list of, like, there's like, I don't know, 50 different items that you have to meet and when it goes before the Board of Appeals, and one of them is to get a recommendation from the Planning Commission before it comes to the Board of Appeals. So it works out well because you guys obviously meet in the beginning of the month and the Board of Appeals meets in the last week of the month. So we can actually do you all together essentially the same month.
But is that issue driven? And I understand whatever the criteria is, but is it issue driven or is it subjective where the staff can select a particular issue to recommend to the Board of Appeals?
I'm not.
Can I speak to that?
Sure.
I think it's driven by special exception.
Yeah, it's a special.
Is that it? Okay,
Yeah,
that's
it. Yeah,
that's what I want to know.
yeah, that's it.
Okay, all right.
Yeah.
And in terms of the notice provision, so it's coming in front of us, do we give the same notice to, to surrounding property owners, et cetera, that we would typically give for a matter before us?
Yeah, in this case, it's a little different. So normally, well, I shouldn't say normally, but like when we do notify, typically when it's in our ordinance, it's a 200-foot radius. So we go out 200 feet. GIS helps us. They make a circle essentially, and we notify everybody within 200 feet. In this case, it's only the adjacent property owners that got notified. That's what it says in the code, and so that's what we followed. So it's just adjacent property owners. I'm sorry. Never mind. I'm thinking of the other. Apologize. I'm thinking of the other issue. So in this case, with Mr. Folks, trying to remember now. Apologize. This does not get notified at this level at the Planning Commission, but when it goes to Board of Appeals, it will get notified there's a 200-foot radius that will get notified. Technically, you guys can say that it has to be more than that if you want. You could say 400 feet or whatever. The other item that's on your agenda tonight has specific criteria that only the adjacent property owners get notified, and it's because it's a condition or a conditional use. Yeah. So a conceptual. I'm sorry, it's at the conceptual stage. So we just notify the adjacent property owners for conceptual. I don't know if that helps. If that makes sense.
Right. I mean, I've just got to work through that in terms of it's a pretty important issue, and I'm just trying to understand.
So nobody was notified because this item has not gone to Board of Appeals yet. All you all are doing is making a recommendation tonight, and so we basically, I sort of prepared the staff report as if it was going to Board of Appeals, but basically put recommendation from the Planning Commission. So you got all the information that the Board of Appeals will get, but as far as notification, we're not required to notify anybody until it goes to Board of Appeals.
Okay. All right. Well, staff, do you want to start?
Sure. So as mentioned, this is a request by Damian Folks for a special exception to permit a residential care home, which is a type of small intermediate care institution at 506 South Regulator Drive. And if you want to flip the next slide, and you can can actually go to the next one as well. So I'm doing this mainly for the audience and for anybody who's watching. So this is a nursing, in our code right now, and this, as you all know, we took this all the way to the city council, and then it got pushed back down to you all again. But this item is an intermediate care institution, and it is a special exception in any residential zoning district. And the neighborhood where this is located is considered or is in the residential zoning district, so it's a special exception. And then if you go to the next slide, I just showed. So unfortunately, Google Earth doesn't have the actual house that this would be in is not shown, so that the neighborhood wasn't built out enough when Google Earth came through there. But this is a typical house. I just took a picture of a house that's in the neighborhood, so similar to this. I can't say that it's exactly the same. And then if you go to the next slide. So these are some pretty important items. So the Board of Appeals may authorize the establishment of a special exception as conveyed in the residential zoning district for an intermediate care institution, and that was stated in Table 1 of Article 4 of this ordinance. I want to be very clear about this. This is not a group home. It's not a recovery residence. It's not a halfway house. And so unlike those three uses, which are overseen by federal regulations, a nursing care institution and an intermediate care institution, which is a residential care home essentially, must adhere to local provisions. And these are conveyed by the city's code and the staff. So they're not conveyed by any federal regulations. And then as conveyed, a residential care home is a type of intermediate care institution that, quote, provides care to individuals who, because of advanced age or physical or mental disability, require domiciliary care or personal care in a protective environment. Basically, this is similar to an assisted living facility, but at a much smaller or at a very small scale. The city just doesn't call it that currently. And then, whereas an intermediate care institution is an institution or home-based facility licensed pursuant to Maryland Code, and I won't read the section of the code, but it basically says, quote, providing accommodations for not less than two unrelated persons who are dependent on the administrator, operator, or proprietor for nursing care, or, and this is the important part, the subsistence of daily living in a safe, sanitary, and healthful environment, and more specifically, it maintains conditions or facilities and equipment to provide domiciliary, personal, or nursing care. It admits or retains the individuals for overnight care. It shall be classified as a care home or a nursing care home pursuant to Maryland Code, and I won't go into the actual code number. And then letter D is it obtains a certificate of need where applicable under Maryland Code. And so those are the provisions for that. And then I also, if you go to the next slide, I just wanted to make it very clear, again, that I already stated what it wasn't, and I want to say that, so it's been stated by many residents, or that many residents moved to the Longboat Estates subdivision because they thought it was primarily restricted to single-family living, and I certainly understand that, and we understand that as a staff. However, the city's Unified Development Code allows an intermediate care institution as a special exception in any neighborhood that is zoned residential, and this neighborhood is zoned residential. The Homeowners Association for the community can establish more restrictive rules and regulations than the city's Unified Development Code. However, if they are to do so, such a challenge would likely take place in civil court. Certainly you can help me on that. I believe I'm correct on that. But in this case, the city is simply following its own rules, which permits a special exception for this use. And then if you want to go to the next page, these are all regulations that come out of our code that are specific to when it gets to the Board of Appeals. So the first item up there basically says, if approved, any building or zoning and occupancy permit must conform with the special exception. The second item up there says, once established, the use shall be conducted in strict accordance with any condition or restriction imposed by the Board of Appeals and all other requirements of this ordinance. And the third item up there says that once the special exception use is approved, the use shall not be considered a non-conforming use, but shall be, without further action, considered a conforming use. And so that's important as well. And then if you go to the next page, there's some standards for consideration. The Board of Appeals shall grant a special exception unless it finds from a preponderance of evidence of record that the proposed use submitted for a special exception would have adverse impacts at its proposed particular location, which would be above and beyond those inherently associated with the proposed use, irrespective of its location with the zoning district. And I wanted to show this because I do feel like, so there's no rules actually in the code as to what you all are supposed to be reviewing. So I basically felt like, I'm going to put what the Board of Appeals reviews, and your recommendation will be based on that essentially. So I feel like these are important items for that reason. Under termination or revocation, the first item says that the special exception, is good for an indefinite period of time unless the use ceases for a minimum of 1 year, and then it shall terminate. So if they receive the special exception, it's good for an indefinite period. Unless that use were to go away, then it obviously terminates after a year. The second item up there says the Board of Appeals may revoke a special exception at any time for failing to meet the provisions, and it does have a process that, if someone wanted to say like, hey, wait a minute, I want to challenge that, and there's a certain amount of time that they can ask for a hearing before the Board of Appeals to go before the board and challenge the revocation of the permit. And then the third item says that the holder of the special exception shall have the right. I'm sorry, I already said that, to the hearing. So yeah, and then if you go to the last page, or it's not quite the last page, but so our recommendation is essentially that number one, so I'm going to read. So there are. Let's see, what are there? There's seven items in our code that essentially, if you can meet those, it doesn't outright say that you should give them the special exception, but it comes pretty close to it. And so these are the 7 items, and I've summarized a little bit. Number one is the establishment and operation of the special exception at its proposed location will not be detrimental to safety or general welfare. Number 2, the special exception at its proposed location will be harmonious in character and appropriate in appearance with its surroundings. It will not disrupt the use and enjoyment of other property in the neighborhood for those uses that are already permitted. Number 3, I'm summarizing here, or in our own opinion, but we lack any evidence that the special exception will substantially diminish or impair property values within the community. In other neighborhoods around the city where these uses have been cited within the city of Cambridge, the overall property values in the community have continued to climb, often substantially. So just having the one house with that use has not actually caused the whole neighborhood to go down in any value. And then if you go to the next page, so A and B I already told you about earlier, so I'm not going to go into those two. It's obviously pretty long, as you can see. If you go to the next page, number 4, the staff feels as though the establishment of the special exception at its proposed location will in no way impede the normal or orderly development and improvement of surrounding properties. And it goes on and talks about just water and sewer, access to streets, drainage, and things like that. And we don't feel like it's going to have any impact on that. Number 5, staff feels as though the special exception will in no way cause pedestrian, bicycle, or vehicle traffic that somehow conflicts with regular neighborhood traffic. Number 6, the special exception shall in all other respects conform to the applicable regulations of the district in which it is located and to the special requirements that may be established for the specific use. And number 7, the proposed use at the proposed location conforms to the comprehensive plan. And I will say that this is not one that's really addressed that much in our comp plan, but there is one item in 4.8 under land use development policies. There's a bullet point that says develop a strong and vibrant residential community in and around downtown, substantially increase permitted residential densities, substantively improve the housing options for the city's residents. And I feel like that this does meet that requirement. So as a result, I kind of summarized into three items. I said the staff believes the applicant can supply additional details regarding the use, and I believe they're here and they'll do so. An analysis of the proposal using the above criteria conveys that it should be amenable to the city's standards for a special exception, and assuming that the applicant can meet all the required criteria, staff recommends that the proposal be approved by the Planning Commission and ultimately the Board of Appeals. There is one condition at the very bottom in red there that we've attached to this. We've said that we've added this condition, and basically, and the applicant is aware of this, that prior to receiving a zoning verification certificate from the city, the applicant must show proof that 506 South Regulator Drive has been accredited and licensed for occupancy as an intermediate care facility by the state of Maryland. So they will have to show us that the state of Maryland, agrees with this facility going there, and we'll, if they do, we'll certainly sign off on it, assuming that it's passed by you all and the Board of Appeals. The last two pages were given to me rather late, and so I apologize, they're not in your packet. So this is just, the applicant sent this in. It basically, they were sent to me today, and the first item is, I guess he can speak a little bit more to it, but it's a long-term care learning center, Maryland ALM 20-hour training. It's to certify that Lawanda Johnson successfully completed 20 hours of department-approved continuing education for COMAR, and there's a regulation there. And then the last page shows that the certificate for successful completion of OHCQ approved 80-hour assisted living manager training program, and it has the name of the person there, and that they did the 80 hours, and they've received this certificate for that as well. And then that's it. That's all I have.
Okay, thank you. Any comments before we have the applicant speak? Mr. Craig, Commissioner Craig?
No, I want to wait till after the applicant speaks.
All right, Commissioner Nelson?
No,
Anything ahead of time? Commissioner
We'll
Lowry?
wait till the applicant.
Commissioner Losty?
I do have some comments, but I think I'll wait. I'll look forward to hearing the applicant. Thank you.
Commissioner Stanley? Anything?
No,
Richard Pluto? Okay, well, let's open the public hearing. And do we have a motion to open the public hearing? All right,
second.
it's so moved. And let's hear from the applicant. Who is the applicant? If you go up to the podium, please, and state your name for the record.
Yes.
And address.
Yes. Damian Folks, 506 South Regulator Drive. I'm the applicant, trying to establish intermediate care for elderly that need support in their daily life. I think it's a great benefit for the community. This is not our first home, so we have done it previously in Cambridge. It works very well. There's a demand for it, so I just want to continue taking care of our elderly the best way we can. We have staff that is well trained, as was showed in the slide. So we're not doing anything differently than intermediate care. It's not a group home or halfway home or anything that's questionable. It's definitely just taking care of people that needs it. So looking forward for the approval or the recommendation to go on to the Board of Appeal.
Anything else?
Questions?
All right. Commissioner Craig, any questions?
You're not the owner of the property, is that right, Mr. Folks? The deed says the property is owned by
Well,
Joel.
he's my cousin
Okay.
and partner.
So is that person going to be involved in this?
Yes.
Okay. And because I looked at your deed, there's an affidavit attached to your deed that says the owner of the property has to live there 7 months a year. Is that the intent?
He lives there as well.
So he's staying there.
Yes.
Okay.
Commissioner Nelson?
Do you need proof of that?
I don't know how to prove it. I mean, you just testified, so
Okay.
hopefully that's the right answer. You'll get your chance, hang on.
Okay, Mr. Pope, you said that you have another, property here in Cambridge. Where
Yes.
is that located at?
Winter Sport.
Winter Sport, okay. Okay, I'm done for now.
Commissioner Howard?
Yeah, a few questions. So, inasmuch as, at least under our code, it's considered a care home or nursing home, so is there gonna be 24/7 provision of nursing care of some sort?
Yes.
And who would be staffing that? LPN or RN or?
Either a CNA or someone with that background to take care. But along with that is a delegated nurse that oversees.
What's that again?
Delegated nurse or RN that oversees.
Okay, and is this the type of facility that'll have a visiting physician, or will these people be seen by their own physicians, own medical personnel?
Right. So
needed.
it's just like us have our own preference. So whoever their preference is, we take them to their appointments.
The house itself is a two-story house?
Yes.
It's a two-story house. So will some of these people be housed upstairs and some downstairs? I
Yes.
think the application's for 2 to 6, correct?
Well, we're only licensed to 5.
You'll be licensed for 5, okay. And so, in terms of elderly people, which
Yes.
I presume this will mostly be the case,
Yes.
how do they navigate the stairs? Do you have lifts, or
Yes.
you will have a lift?
There's currently one installed.
Okay. Are you aware of the covenants that exist in the homeowners association that we have been at least informally advised of? I don't know if I've ever seen anything in writing. One of the covenants was as I understand it, a prohibition against operating a business. And then someone made me aware of another one, but again, I can't verify it, that there's a no street parking provision.
Okay. Yes.
Okay, so you're aware of both of those?
No street parking. I must have overlooked that one. I didn't see that, but okay. But we have a driveway and a garage, so
Okay.
we could adhere to that.
So in terms of the first one, have you ever heard of that, or have you confronted that, the issue of no businesses operating under the HOA covenants?
What date was that drafted up?
Well, our understanding, what we've been told previously, not in any formal filing,
Nothing's come to the city.
was that there were covenants that are established by the HOA, which is pretty normal for HOA, about not operating a business out of out of a home there, and of course this is a home. Now, and I only ask that if you're aware of that. We don't necessarily enforce covenants, or they're not in our code, but I mean, I think does have somewhat of a bearing on a recommendation.
I would say when the house was purchased, when the business was registered and was applied for license, it didn't exist.
So is the house a primary residence now?
Yes.
It is? Okay, so it'll cease to be a primary residence.
Yes.
Okay. are you required to have as a license restriction or whatever, a commercial type kitchen, or can you do this out of a residential kitchen? Will you be serving 3 meals a day in there?
and snacks.
Okay. How far away do you intend on seeking patients? In other words, is your area of focus here, or you're going to advertise across the state, or?
Well, currently we don't do much advertising. It's mostly word of mouth. And since we work closely with the state of Maryland, Quality of Health Care or Department of Health, so we don't restrict the state of Maryland how or where we work with the state of Maryland.
Okay. So you've applied for the license. Do you actually have a license in hand, or?
We're still meeting their requirements.
Okay. Okay. Okay, that's my questions.
Commissioner Ralston.
Okay, thank you. First, I'd like to say welcome.
Thanks.
And I'm 100% in favor of assisted living as our population ages. My concern is that I would really like to delve into this covenant, because as a realtor, I know that covenants restricted, whether it's the Deepwater or your development or the Hyatt, that the covenants and HOA agreements are so important to buyers of the community that they are given, in some instances, 7 calendar days and some 15 calendar days to get out of the contract if there's anything in the document that they don't agree. That's how important it is to the buyer to be in an association that they agree, and they may be 2 owners or they may not be owners enough. As a matter of fact, just at Oakley Beach 3 months ago, I had someone, we were supposed to close in 6 days. It was within the 15-day window. They called and said, I don't like the documents, and you're allowed to get out. That's state law. So my question is, I think I looked it up, and the buyer closed on November 21st of 23, according to the tax records. Do we know for certain that the provision saying no business was not in the documents as of November of 23?
Yes.
We do.
I'm going to jump in. How would you know that if you're not the buyer of the house?
Because I went through the documents.
So I just want to be clear. You've been through the HOA documents, and you're telling us, as a representative, that there's no covenant or provision in the HOA documents that prohibit a business from being operated, a business of the sort that you're applying for. I just want to understand, you're on the record. I want to be very clear with that.
Yes, when I went through it, I did not see that.
So that was as of the 2023 or as of now? Do we have the documents? That would be the easiest way to...
No, but the city doesn't have the ability. The city's only, and I've tried to convey this, that all you are doing is addressing the use and whether or not the use is allowed. That if you were getting into covenants and things like that, that goes to a whole other level.
Well, that goes to
The
the use.
planning commission doesn't enforce private covenants.
I know we don't, but we would be doing community a disservice if we approve something and then the HOA has to sue to undo something we've approved. I think it's a disservice to the
But you're
community.
doing a disservice if you don't follow the code of the city.
Well,
I mean, you have to
Code
follow the
doesn't
code.
require that.
Yeah, the code doesn't require that. I mean,
Well, then we need to work on the code, because he can come here, hold on, he can come here and we can approve it, and then he can go do what he wants to do, and then the HOA has to spend money and sue to undo something we've done. I just want to, that's your view.
Excuse me. Can you repeat doing what I want to do? We're not doing what we want to do. We're stating exactly what we're trying to do. It's not anything differently from what we're projecting.
Okay, well, I mean, we're not done yet, but
No.
yeah.
Okay, so my only comment, and this would be for our attorney, given that it's a state law that people can get out of a contract if they don't like anything at all in the covenants or the HOA within the 15 or the 7-day calendar, before closing. From the day they get it, they have 15 days to review. Have you looked up state law when there's a conflict between an HOA prohibition and a city code? I started doing that and I ran out of time. Do you know the answer?
I believe that they're two different things. That the city code, in other words, if he gets a special if they were to get a special exception to have this use, but there are private covenants that say they can't do it, they can't do it. The special exception doesn't override the covenant. So, but it doesn't mean the planning commission or the board of appeals enforces those covenants. They're private covenants. You have the authority delegated to you under state law and under the zoning code.
Wait, I'm not clear. So you're saying, so do we understand, is there or is there not at this time a provision saying no business in this association?
I don't know. That's not in the record. That's not before.
Well, I think that's important for us to understand.
So
Do you
that's
know?
gonna have to come from, who we hear from the housing, HOA.
Yep.
That's what we gotta hear from them first before we can make this decision.
Oh, absolutely, I agree.
We
Yeah.
can't make it unless we hear from them, and that is stated from the time that he purchased the house, in order for us to.
Right, so we'll
clearly
hear
make
from
a-
them.
Yeah.
So the only other thing I wanted to
do it
comment
without
was that it said that if you, the person who's asking for the special exception, if you're not the property owner, which I guess you're the lessee, then you would just need to have a written statement, part of the application from the property owner endorsing this use.
Okay.
So if that's your cousin and he's involved and he is fulfilling the 7 out of 12 months to live in the house, then I would think getting that would be no problem. But I just wanted to comment, that's on Brian's page number 4 under the board, right above termination or revocation.
Can you repeat that one more time?
It would just say that you would need a letter. It says, an application for a special exception may be made by a property owner, a lessee, or a contract purchaser. So you would be the lessee. A lessee or contract purchaser must file with the application a copy of the contract or some form of written statement which indicates endorsement of the application by the property owner.
Well, the property owner is part owner of the business, so that's no problem.
Okay, all right. I just wanted to,
Okay.
that seems to be lacking, so I just
Okay.
wanted to make sure if you perceive that you have that.
Okay.
Thank you.
No, my only thing is just the HOA presenting that as the date that he purchased the home, that inside of that the covenant was there when he purchased the home, that it stated that there was no business allowed in that development. That needs to be presented.
Right.
Because that's the holdup. That's gonna make the difference. He said it wasn't there, they say it's there, so we just need to.
All right, anything else?
No, thank you.
Any questions?
Yeah, my question for staff, just along those lines, is we already have a recommendation that has a condition that we have to comply with state of Maryland requirements. Is it feasible to have another condition that says the application, before awarding the application, it needs to show proof of complying with private covenants?
Or we can make that recommendation if we want to.
And there has been some state law beginning to opine on this case, which is, on this situation.
So I have a question before anybody else testifies. Is this a for-profit business?
Yes, it is.
And what is the name of the business?
Dimples Manor.
I'm sorry?
Dimples Manor.
Okay, Dimples Manor.
But with the HOA, do you have to file that somewhere once you make revisions on your policies and stuff? You have to or is it just? Okay.
Yeah.
Those
All right.
HOA agreements are recorded. in circuit
According to
court.
land records.
Okay, I just wanted to.
Yep. All right, anything else, sir?
Also, I don't know if anyone ever been at a assisted living facility, walking in for their loved one. I've been for my grandma, and ever walked in and you see like it's a hospital room. It doesn't look like a comfortable place. I don't know if anyone ever been in that situation. So that's the reason why we don't have a large facility. We actually use residential because it's still a home feel instead of visitors. And we get this all the time from our clients that it feels so much better than looking at my loved one, my mom, my father, in a hospital bed versus a bed they could bring in or where we provide. They could have their own furniture. It's just a whole different aspect for them to see their loved one move on to wherever the next time of life. So, to just consider.
Right. Thank you very much. I appreciate it. All right, Brian, do we have anybody that's signed up?
Nobody has signed up yet. We have a list up there if they want to get up and speak. And
Good afternoon.
Hold on one second. Do you want them to sign up or no?
if they could just do it when they get up to speak, that would be.
Yeah. So there's is there a pen up there in front of you, ma'am? Would you write your name on that piece of paper and your address, and then please tell us your name and your address.
Okay. Good afternoon. My name is Jeanette Ventura, and I'm living at 1505 Winters Court, Cambridge. I'm the person that started the assisted living. I've been working in assisted living for over 30 odd years, and I see where I could give people that, you know, is the end of their life, give them a better life than the ones that I've been working with. And I decided to open up my home to residents. At first, we started off with 3 residents. The city or the health department, they encouraged me and they asked me, can't you do something about this situation? There's a long line of people waiting to go into assisted living, and they have to be shipped out from this city, sometimes even out of state, because there's nowhere for them to go. And they want to live in a home that's decent, looking good. They just don't want to go into any home or being in a hospital, or because they are not sick. And they are not sick to be in a hospital, and they are not sick well enough to live on their own. So we come in the middle, and we give them love, attention, and decent living. And that's what I'm trying to do. And that is why they encourage me, and I encourage my son. I ask him, you know, can you get on board so we can help these people, because they need help. There's no assisted living in Cambridge, apart from mine and one more lady. They have to go outside of Cambridge. And we have to follow the rules and regulation of the state, because they do an announced visit. And when they gave us the license, we have to comply by that. And we don't know when they come in, because, you know, it's a surprise visit, because they want us to make sure that we are doing the right thing, and that's what we have been doing. I've been doing it since 2011, and I don't have a complaint. So I just asking you, you know, just to think about it, consider it, think about a loved one. You know, this is they give all their life here, and they want to stay in Cambridge. And a lot of them don't have family nor friends visiting. They just, you know, they might get 1 and 2 phone calls. They don't have people visiting them. So when they're in a loving environment, they're happy. And it's their last days, and, you know, they want to live the best life that they can live. Thank you.
Thank you, Ms. Ventura.
Good evening, everyone. Thank you for this opportunity to speak. As I write and speak at the same time, I hope I can do that. My name is Mark Elliott. I live at 130 Regulator Drive North. I've been a proud member of Longbow for 18 years. And I have some things I'd like to address. If I can ask the gentleman to move some slides back, but before I do that, since it came up, I do want to address those HOA concerns immediately. Had I known, I would have brought it with me. I apologize, but I have that thick thing. So, along with things like no livestock and everything else that is on the covenants, there are 2 things that based upon our conversation, that are in there as of when we bought in 2007, 6, 7. A, no permanent street parking, and B, non-impact businesses are allowed only. And by that definition, we have evolved to say if you have an accounting thing in your house or crafts in your garage, things like, but not a business like this. Now, we've been here before. There was another property on Albemarle Court back in November, I believe, or at least last summer, that this came up. Someone came in, bought a foreclosed home, I think, and tried to get this business in, was doing upgrades inside, putting chairlifts and doing everything without even letting the HOA know what was happening. So as you can imagine, and first of all, let me backtrack for the record. I come here as a concerned resident and citizen. I am not on the board of the HOA at this point in time. I was a former board member on the HOA, and I was on the bylaw committee, so I do have a little bit of background with this, but I come tonight to you as a resident. And we are concerned when businesses like this, and I applaud your intention. As someone with gray hair, I certainly applaud your intention and the need. But we firmly believe that Longboat Estates is not the neighborhood for this. First and foremost, because our HOA went through, we took over just a couple years ago from the original developer, there was one of these businesses that, I hate to use the word snuck in, but developed under the radar. No one knew what happened. At 206 Regulator South. So you already have something like this happening. And I believe there's a comment from this board, or this room several months ago, that there was a concern about the proximity of these businesses developing. So I can tell you right now, there's already something happening in place. So that being said, the concern is to address your HOA concerns. It's in writing. And if we have the ability to present this at the Special Board of Appeals, if that's, and I would also say 200 feet, I humbly request that you announce this Special Board of Appeals meeting to the entire community, not just a 200-foot perimeter of this house. This is important information because, and if I can go back to some of those summaries that the gentleman pointed out, no impact on the community. We already have a problem with speeding. We have over 130 homes in this community. It's a beautiful community. I love living there. My grandchildren love visiting. We're up to 130. We have trouble now with the city of Cambridge to get stop signs put in place. People are speeding. So in this additional traffic, that's why we don't want businesses in there of any kind where it has an impact. We have parking issues. Cars are being hit because people are driving too fast. So we can't even get lousy speed bumps or stop signs from the city of Cambridge. I know that's not your concerns. But you add more businesses in there, you're going to have additional concerns. And there are a lot of kids running around in those streets playing. And that's why we don't want these cars increase the traffic. Secondly, and more important to your clients and residents, this particular address is only about 7 house lots away from a ramp to Jenkins Creek. So I don't know how the activity for residents occur. I would like to think if I was in a facility like this, I wouldn't be cooped up in, I don't know if it's 3 or 4 bedrooms in that house, and if you have 5 residents with 2.5 bathrooms. But if you're cooped in, I'm sure you want to get out. It's a beautiful community. It's a beautiful area. I hope I never lose all of the ospreys and everything else. But I see that as a dangerous element of having water on that side of the community, 7 houses away, and we have a swimming pool, which we are going through now, and we possibly may do away with our lifeguards as a self-regulated swimming pool. There are hazards there of what I'm trying to get to the residents. So let me summarize, because I don't want to talk all night. You folks have a lot of business. The HOA stipulates the concerns you brought up. I would be happy to bring them at the Board of Appeals meeting if I'm allowed to do that. And I don't even know if that's open to the public. And secondly, we really feel that this community is not the best place for this kind of well-warranted business. And it is a for-profit business, and it's well-warranted, but not in this particular community. Thank you.
Thank you, Mr. Elliott.
Can I ask a question?
Yes.
I have a question. You said a similar business is already operating there?
It came in under the radar. I hate to use another term like that, but I'm sorry. It is some type of assisted living or group home. It was never, and that's the other thing I should say. We did change on the HOA this just recently, within the last 6 or 8 months, that any businesses, non-impact businesses, have to register with the HOA. So this is obviously an impact business. No one's ever registered anything to the best of my knowledge. But to answer your question, there is an activity going on already, literally 2 blocks away.
And to your knowledge, has the HOA tried to enforce the covenants?
We're trying. We've explored some legal activity, and as you meant, we're just a little HOA trying to keep our what's the word? well, the, you know, what do you call that, where you have to have so much money for the,
Are you reserved?
your reserve, thank you very much. I know a realtor will come to my rescue. We're trying to keep our reserve situation above float, and we're not certainly trying to pay, with all due respect to all the lawyers in the world, but that's probably the route we have to go. I think, and I'm not speaking for the board, but I think the board is exploring that. I hope that answers your question. Thank you.
Any other questions?
Yes, so I understand that you're not on the board, but do you know if the board, the HOA must have an attorney,
Yes.
right? Do you know if the HOA has gone to the attorney to get an opinion on whether he believes the covenant would be enforceable in this particular case?
I don't think it, I don't know. To give you that, I don't know the conversations that took place. I know that there's been conversations with their lawyers over that. I heard that there was conversations taking place. I'm not privy to that, and I hate to see.
Because, I mean, the money aspect kind of doesn't wash with me. I've been on a condo board for years, still active, but not on the board, and, you know, in the rare times we've got to go to an attorney to at least get an opinion on what you think, it's not all that much money. Now, you got to go to court, but he's convinced you win. That's you know, you
Right.
might get that back, actually.
Good point. I'd have to defer that to the current board.
I mean, we've heard a lot of things, but no board members ever come here yet. Not one board member that I know of.
Part of it could be
And
that,
if it's such a concern, where are they?
well, part of it could be the board's not getting notice.
That's exactly right, sir. We don't get notice on this. You know, again, there's the two, we don't, which is.
Yeah, I understand. I do understand
That's the
that.
frustration, and that's what happened when these things, all of a sudden, I sent a post on our little Facebook page this afternoon. Hey, we heard this has happened. There's a meeting tonight. That's what we're operating under. There's no I know legally they don't have to, but there's no communication coming to us that, hey, these things are developing, unless someone walks by and we see things happening in the house.
Yeah, and I know that some of the HOAs they operate a little differently than some of the condos operate. I mean, we're very involved in everything, but that it just is. It's just baffling that it. Do you have a management company?
Yes, we just switched to a new one. Yes.
Okay.
That's a yes.
And have they been contacted at all? Do you know?
I can only speak from the experience of our previous management company, who just basically deferred to, you have to talk to the lawyer and let the lawyer go through that aspect. And again, I don't want to put words in the board members' mouths.
Right.
What conversations they had.
Okay, I appreciate it.
Absolutely. Thanks, sir. Thank you.
Any other questions, Commissioner Lowenstein?
Not at the moment, thank you.
Any questions? Bobby?
No, I'm just waiting for a couple more.
Questions? Thank you, Mr. Elliott.
Yes.
Yeah, thank you.
Good evening. My name is Carrie Asbell, and I live directly across from the property, and I did not know about this. I don't know if I'm directly 200 square feet or whatever you got to do, but I am directly across from the property and did not realize it until it...
There's no notification required for this hearing with you all. And just so you know, I mean, because we're getting slammed here, like, both Dean and I have worked in, like, probably 10 other cities, and we never had to notify an event like this. So
We're not the decision maker, basically.
I just wanted to I live across the street, so I have very good notice of what goes on over there. First of all, I'm very familiar with, and I know he wants to play to your heartstrings and everything. I did have a parent that is presently in independent living, and my father was in assisted living in a Frederick, Maryland place, and so I understand all the people that are going to be coming and going within a assisted living program. So you're going to be talking about doctors, nurses, caretakers if they need that, occupational therapists if they need that, PT. You're going to have somebody cooking. So family members, there are a lot of family members that do visit people in assisted living, not as much as probably we wish that they would. But that is also going to impede the traffic that is in our neighborhood. And like I said, I'm directly across the street. The roads are narrow. When you put cars on each side parked and then try to fit, you can't fit 2 cars down. One person, you can only go down one way when you have cars parked on the sides of the streets. The same with the driveway. The driveway is not a wide driveway. I have my college student that is home right now, and we're constantly moving cars around because there's nowhere to put 3 cars. So that will impede the traffic situation. It'll be detrimental to that because we do have a lot of kids that walk to the pool. We have a lot of kids that walk to the dock and use those privileges, as well as walking to the bus stop, which is on, I can't think of the corner, F&S Drive. There's a bus stop there. So you're going to have children that do walk up that way, which will be a traffic hazard as well. And like we said, the stop signs are there. It took us forever to get those. So my biggest thing with me is the safety. I would like to respectfully dispute what this gentleman said about that house being lived in by the owner. As living across the street, that owner has not lived in that house the entire time since he bought the house. It has been empty for 2 years. At one point, this owner, Noel, whatever his last name is, was renting out to other people. Multiple families were in that residence at one time. So that was against the homeowners association, I believe, as well, because I think you can only have so many people or whatever it is. Like I said, I don't have all the details. But the house has been empty for over 2 years, except for subletting to other families that were in there. At one point, that residence was also condemned by the city of Cambridge. Sorry, my leg's shaking. I'm so nervous. It had the condemned sign on the front door because the water had been turned off. And the residents that were in that building renting from the owner, I suspect, I don't know who's in charge of the water, whatever, but I went out one day and there's like water things that are in the ground, little circle things. The renters were out there and they were tapping on it because they wanted to flip it open to try to, figure out how to turn the water back on. So that residence also did not have any curtains. So my point is that house, I'm disputing what he said. So if he's telling you one thing, I don't believe anything that he said because the residence has not been lived in by the owner since the owner purchased the property. As I said, I'm directly across the street. I see everything that goes on over there, and it has been empty except for subletting to multiple families that live there during a landscape. They have a landscaping business, so they weren't there in the winter either. So it was a short period of time that renters were in there.
Okay.
That's it. Thank you.
Thank you. Any questions from anybody? Okay. Thank you very much, Ms. Alf.
Thank you.
May I ask real quick, when is that special meeting, special Board of Appeals meeting? Is there a date on
It's
that?
the end of the month. There's the date.
Brian, do you know when the Board of Appeals meeting is?
Yeah, just a second. I'm sorry. It's at the end of the month.
It's the last Thursday, Brian, of the month.
Yeah, hold on. Give me 1 second. I'll get my calendar. Sorry. It is the January. I have the 27th, which is a Tuesday.
And it's probably online as well, so just if you go to the Board of Appeals.
It's on. If you go to the city's website, I'll do that.
Okay, Board of Appeals, is it in this building?
The Board of Appeals hearing will be here. Yes, that's correct.
Thank you.
All right, anybody else?
January 20th.
I mean, you've already testified. Did anybody want to hear from the applicant again?
Yeah, I'd like to.
Go
I
ahead, sir.
think it would be.
Yep, go ahead. And just again, state your name for the record, please.
Yes, all right, this time.
Well, you don't need to write it down again, but.
I didn't write when the first one.
First time is speaking as the applicant.
Okay.
Oh, I do it since I'm an applicant. I don't need.
You're good.
You're
You're
good.
good. Yeah. It's okay. They don't have the 2026 dates on there. Did you see it? I didn't find it. Yeah, I wasn't told about that.
Understand you're concerned about my cousin staying there and the people that you saw there. As you heard, which is my mom. Jenna Ventura. Her name is Ventura. His family. He has a room. He stays there. He could have a room and have family there. It wasn't rented. There's no document, no anything that said it was rented. It was just family. My cousin stays there. He comes, and he has to be there. We have, if we I have it in the car where his name is there, he's received mail there, everything that shows that's his permanent resident, that he stays there. So that's all I ask, that you need a proof to show. We have it, but it wasn't rented. It was family. And the time of the water, I don't believe they were there any longer, because that happened after they left. So they weren't tapping on anything to change anything. Curtains are there now. There's something we knew of, so that's it, right? But they're up now to prevent privacy. But that's all I wanted to address.
Okay, thank you very much. Any questions?
No, thank you.
Mr. Chairman, just one question for the lady who just testified. So, first of all, do you allow Airbnbs in the Longboat Estates? Short-term rentals?
Yeah, we do. And I say they're vagaries, I'm not sure.
Okay. How would you describe the community in terms of age of the families? Are there a lot of kids in the community? Pretty much a mixed community, but a lot of children?
I would say, what would you say? There's a good load of children. I mean, if they have a bus stop, obviously, and there's a bus that comes through and picks the kids up. They go to Sandy Hill. I know there's several teenagers that are in the building because development, because they go down and they'll fish down at the dock. I'll see them with their fishing poles and stuff going down there. And I go to and I'm a educator, so I have most of the summer off, and I am at the pool, and I do see lots of kids there. So I'm at the pool almost every day the whole entire summer.
Okay. Thank you.
I have one question. You said it's a business that's like the assisted living facility that's already in your neighborhood that popped up?
Yes.
Is there a problem with that business now? Do you have issues with that business currently?
None that I can speak to.
Have the neighbors from that facility expressed any concerns?
I have not heard of any, but I think the concern is the fact that it went against the HOA guidelines, and then as you know, you use some of the Pandora boxes.
You said it's called like a non-impact business that's in the covenant, right?
Yes, ma'am.
Okay.
Anybody else? We'll close the public hearing. All right. Commissioner Pluta, you want to start? Any questions or comments?
I think mine have largely been addressed. I'm hanging on this condition here that requires the state of Maryland license to be approved before the special exception can go forward. I'm hearing now that the HOA requires approval or a notice or application of some sort of non-impact businesses going in there. And so, I've seen it before where these approvals are contingent on other local approvals happening, and so in a perfect world I'd like to see where this has been approved by all entities involved in order to recommend a positive recommendation. But I don't know if that's
right.
That's
Commissioner Craig, or who wants to start? Any comments or concerns?
I personally think that this probably doesn't belong there, but I feel really constrained by what the code says. I also think there hasn't been enough push by the homeowners association itself to resolve an issue, which it probably should be. And so, personally, again, I think if the dwelling were to, as long as it didn't look like a business, it probably wouldn't draw too much attention. I think there will be some ambulance calls. There'll probably be, food deliveries, although some instances the owner can, or lessee or whatever it's going to be, can go out and bring those back. But I don't see it as a huge traffic generator. But I don't think it actually belongs in a community like that, but I feel hemmed in by the code, and I don't think it's a huge safety issue, but I think it's more along the lines of, general welfare. I don't believe that putting one of these in increases property values in the least. Probably has a neutral effect if it's run well. 5 residents probably aren't too many. But I guess in my own mind, I believe it's got to be something the HOA pursues. So it's kind of where I'm at after hearing everything.
Anybody else?
I agree pretty much with Gene, and I think, well, secondly, I certainly support assisted living. I'm getting there myself, probably, so, I got to consider that. But anyway, I'm concerned about the HOA stuff, and so my concern is whatever recommendation we send to the Board of Appeals, it specifically is on the record that we are not speaking to the HOA requirements. We're only dealing with the zoning ordinance. We got to separate that out explicitly for the record. So that's what I have.
Yeah.
Mary?
So what I would like to say, as pro home care as I am, I think that I would be disinclined to suggest a positive recommendation, because we have thousands of housing units that are not within an HOA. As a realtor, I understand how important these HOA documents are. So important that people can withdraw up to the day before a contract if it's within the 15 days if they don't like the contracts. Therefore, and I think that this is going to be adjudicated at the state level, and I would ask our attorney to take a look, please. Just the same thing with short-term rentals. The city could say yes, they could say no. This same issue is going to come up in a variety of ways, and it is being litigated, so I think it would be good to hear what the state has to say. The fact that the state dictates the HOA documents being recorded and having this bailout if you don't like them tells me that the state thinks the HOA is fairly important. So I would be disinclined for a favorable recommendation.
Well, I basically agree with Gene as well. Our hands are basically tied. I'm going to follow with the code.
Yeah.
We have to follow the codes. And also what Commissioner Craig said, that we have to separate it from the HOA covenant.
Can I say one more thing? I think the HOA stuff, you definitely need to get to the Board of Appeals. That's where they should be. That's that level where you present that. They've got more latitude. That's a quasi-legal body. They got the latitude to consider that better than we do.
Well, I'm going to telegraph my vote. I mean, I'm looking at the special exception, and it's required to be harmonious in character with its surroundings. I don't think this isn't harmonious in character at all. So I think we are following the code. I think I don't think special exception, this merits a special exception because it's not in character with the surrounding houses. I drove by there a couple days ago, and the roads are narrow. And if you talk about parking, it's correct. There'll be doctors, there'll be nurses, there'll be family members, there'll be OTs, there'll be PTs, there might be inspectors. This is it's a house on a very narrow piece of property, and do we really believe that that there's not going to be all sorts of parking all over the street? I think we'd be naive to believe that. I also believe that that it's not in the public interest if we have reason to believe that it's violative of the HOA to approve something and then leave it to the HOA to resolve in court. So I would encourage, if it passes, that we require that the HOA either say it doesn't object or that it proves, or alternatively, that the applicant demonstrate that it's not in violation of the HOA covenants. But I'll go back to what I said. I think that it's not harmonious with, in character with the surrounding houses, and that's enough for me to say that that it's not per code, and so I'm not going to approve it. So we've all got our points of view. Does somebody want to make a motion?
I'll start it off. I recommend we give a favorable recommendation to the Board of Appeals with the conditions of there be no business signs, maintenance of the dwelling must conform to the general standard of the rest of the community, no on-street parking, and that would be my, and we can certainly consider parking and traffic as part of our recommendation, so that would be my motion. So that would be favorable with conditions.
All right. All in favor?
You got to get a second.
Oh, is there a second for that?
Second.
Okay. All in favor?
Aye.
All opposed?
Nay.
So we have 4 opposed. We have.
4 in favor? What was it?
Was there 8?
It's 3 in
No,
favor.
3 in
four
favor.
opposed.
4 opposed. So the recommendation.
Well, that's one motion. Is there
Yeah.
another motion?
Is there another motion? I guess that motion fails.
I would make a motion to recommend an unfavorable.
All right. I second. All in favor of that motion? We have 4. All opposed? Okay. So the unfavorable recommendation, Board of Appeals. All right. So moved. Okay. Next on the agenda is PZCS/PS 260001. Applicant Gary Nusinoff, Floriat LLC. And the applicant is seeking both conceptual stage and preliminary stage approval for the industrial site. That's also an optional public hearing. Steph?
Yeah, sorry, just give me 1 second. So as mentioned, the applicant is actually, so normally, when an applicant comes forward, they go for conceptual approval, then a month later they come back for preliminary approval. This applicant stated that they were on a time crunch and that they really needed to move forward, and they would request that they felt like they were had done the sufficient homework and everything that was necessary, and so they requested for both conceptual and preliminary site plan review at this hearing. Obviously, that's up to you ultimately whether you decide to give it or not. But so this is it's an interesting night. So this is a cannabis grow and processing facility, and it's a conditional use in the industrial zone. And I'm gonna try to go through this pretty quickly. So as mentioned, Gary Newsonoff and Floriette LLC are the applicants that I have down. It's 822 Chesapeake Drive. It's a Category 1 site plan. And I mentioned what the use is, and it is a conditional use in the industrial zone. There's only one condition, however. And then you all probably, well, first let me go back, and we talked about this at the beginning of the meeting. So conceptual stage reviews require that verifiable notice be provided to all owners of property that either adjoin or are located immediately across the street from the subject property. Such notice shall be provided no less than 7 days prior to the meeting, and the date, time, place, and subject matter and the name of the applicant has to be provided. We did that, so I just wanted to make sure that that's conveyed. I'm not going to go through. On the cover there, you all remember we went through, we had the place, the industrial site that basically blows things up, and we had an extensive amount of hearings and so forth about that. So I did convey some of that language. Unfortunately, our code has not been updated fully, so anyway, I just wanted to convey some of the language that got adopted on that front page. But if you go to the next page, you can see there is the use actually at the very top in red, and it is listed as a conditional use in the industrial zoning district. And then if you go to the next page, I did try to show some images. The top left is the front facade of the building from Chesapeake Drive. The top right is the left. There's a big field, like an enormous field, on the left side of the building, and you can see that, and that is owned by the property owner, and will be probably used, I'm assuming, for the marijuana growth. And then you can see looking from the west, west to east, kind of looking down Chesapeake Drive with the building on the left side. Again, this is in an industrial park. It's actually behind Walmart, and that's the Dorchester Square Mall right there where Walmart is. And then the aerial view on the bottom right, I'm sorry, the picture's small, but you can see the facility, the amount of land that's around it. It's quite a bit of land behind it and to the left of it. And then you can see the Walmart and the shopping center directly behind that. And so just so you understand this park, I'm sure you probably already do, but just the facilities on one side of the main road in the industrial park, and then on the other side it's also industrial. So what I'm showing you are actually facilities behind and outside of the park when I'm talking about the Walmart. So if you go to the next page, I already gave you the address, and it's 6.29 acres. It's zone industrial. You know what the use is. The only thing I wanted to just say is that the city views this marijuana like a crop, essentially. I know it's kind of weird that it's in an industrial site, but it's a crop. But just keep that in mind when we're getting into setbacks and things like that. The side setbacks, because you have industrial on both sides, they can actually be reduced from 50 to 15 feet. However, on the property across the street is zone industrial, but it doesn't matter. The front setback, it has to be maintained at 50 feet. And the property to the rear of the parcel, as I mentioned, was zone general commercial. So there is a clause that if it were zone industrial, it could go down to, I think it's 15 as well, but because it's not, it has to stay at 50 feet as well. And then fencing was we spent a lot of time talking about fencing just because, as you know, this is an industry that's growing quickly. And anyway, the city's code allows for an 8-foot high fence for various industrial uses, including this use. We talked to the applicant about the use of barbed wire. They wanted barbed wire, and so we asked them to use the straight as opposed to the rolled barbed wire like you would see like at a prison or something. So we're trying to use the sort of cleanest version that we can. The fencing will be permitted in the front, side, and rear yards. There's no fencing allowed around the front entrance of the building or the parking area, so the building and everything will still be maintained as a nice sort of clean facade, and you'll be able to see that and theoretically walk right up to it. The fencing shall continue from the eastern side of the main building at the rear all the way to the eastern property line. And I know this gets a little confusing, but we could talk about fencing for 10 minutes if we wanted to. And there is a standard in our code that says for every foot above 4 feet in height that the fence has to go, and we've agreed tentatively with the applicant to go to 8 feet. The fence has to move 1 foot back from the property line, so they're basically 4 feet over the 4 foot height limit, so they would have to move back 4 feet. However, we feel like this is a good thing. It would provide a little bit of space. The applicant has agreed to put a vegetative buffer along the front of the facility, and they can speak to that with y'all as well. And then if you go to the next page, this is a conditional use, and I just wanted to show. So you can see medical cannabis is listed at least 4 times in our code under uses. It was added, I guess, several years ago. But the conditions are very limited. The only condition that coincides with this use is that it not be located within 1,000 feet of a school, and this particular use is not, so it meets the conditional uses. And then on the next page, this is different from the map that I put in your staff report. The applicant actually sent this in, and it's a lot better than the one that I drew, so if you're okay with it, hopefully. It just shows the fencing. Well, it shows a little bit more than that, but you can see the red line where they want to put the fencing. The main issue that I was talking about earlier was you can see the fence coming across the front, in front of the street, and then so we don't have this required in our code, but I feel like it should be. Right now, with the way our code's written, the fence would basically have to come right up to the corner of the building. That is not something that architecturally or design-wise that you ever really do. And so the applicant had agreed to keep the fence at least 10 feet off of the building, and at least have it pull it back at least 5 feet off of the front facade. So it essentially is just a little bit off of the front corner there. It just makes it look a little nicer aesthetically. There may be some other items up there that they can speak to on this. They actually sent this drawing in, and then we've been through this a number of times. We have landscaping. You can go to the next slide. I'm sorry. We have landscaping requirements. However, this is an existing site, and there's quite a bit of growth for an industrial site on the property. So I do not feel like they need to submit a full landscape plan. They actually already meet technically they meet the entire landscape code. I'm just going to go through these quickly, I guess. The minimum screening requirements, as you all know, we've talked about this extensively. This is something we want to definitely fix in our new code. All service structures, which include dumpsters, providing service to the building or site, shall be fully screened, and landscaping and or a fence or wall should be provided. As far as the perimeter parking lot landscaping, there's requirements about having plantings around the parking lot, essentially. All of those plantings are already existing. The only one that I guess you could question a little bit is on the landscaping strip that's adjacent to the right-of-way, which is in the front, basically, the right-of-way being the road. A compact evergreen hedge, an ornamental wall, or a wooden fence of not less than 4 feet or greater than 6 feet in height is required. As I said, there are, if we went and looked at a picture of the site, you can see there's quite a bit of, they're actually really big. I don't know what you wouldn't call them, shrubs. But they're almost like bushes trees in the front. So I feel like they've met all that. As far as internal landscaping of the parking lot, the lot doesn't have 25 spaces, so it doesn't require internal landscaping. If you go to the next page, there's a requirement for the building wall planting, and what I said was that there are currently I'm not going to go through the requirement, but there are currently 2 shade trees and a hedgerow are located along the front building wall that fronts Chesapeake Drive, and the sidewalk does not allow for any plantings adjacent to the building where it is fronted by off-street parking. So, and what I mean there is where the off-street lot for parking is, basically there is a sidewalk that the curb, it comes right up to the curb, and so there's no grass there, so there's no place that you could plant. I guess you could if you wanted to make them put some planters in, like some sort of like, you know, box trees or box bushes if you really wanted to. But like I said, there's quite a bit of plantings around the site, and it is industrial. So, and then if you get into parking and loading, so, you know, we've gone over parking quite a bit in the past. So, except for as provided in 6.3.3, in all districts, space for parking vehicles shall be provided in accordance with the scheduled minimum off-street parking requirements by land use set forth in Table 4 of this ordinance. In the review and approval of site plans and subdivision plats, in an effort to minimize the amount of impervious surface coverage, and in keeping with 5.1.1C, and implement the purposes of the ordinance, the Planning Commission may require that all or some of the parking surface area on a site or driveway be constructed of pervious surface and approved by the city. And I just, again, this is an existing site. It is what it is. I just feel like, you know, making them put in pervious paving at this point is probably not the best thing. So they do have to put in bicycle parking, and it is required. You can either put in 2 bicycle stalls or 1 stall for every 50 employees. And then for the maximum parking requirements, maximum parking shall be 1 space per staff plus spaces in number as determined by. Okay, so I'm going to read. So for commercial uses, so we considered this. So you got to understand that we have a use table that, you know, we look at for in the back of the code when we're looking at a land use, but then in our parking section we have a whole nother section that kind of breaks down uses, and they don't always coordinate with one another. The closest use in the parking section was the use was called nursery for plants / greenhouses, and the maximum parking shall be 1 space per staff plus spaces in number as determined by the approving authority, which would be you all, the Planning Commission, that serves the visiting public. I don't think there's going to be a lot of visiting public coming to the site, so the applicants can certainly speak to the number of parking spaces that they need, but I'm going to guess there's probably 20 spaces in that lot. 22, okay. Yeah, and so as far as modifying the parking standards, as you know, in other zoning districts, the maximum parking requirement shall be adhered to, except under no circumstance may the numerical standards be exceeded by more than 20%. We've gone around this standard quite a bit, but I doubt, unless they ask for additional parking, in which case you could, you know, add the pervious paving and things like that. I don't think this is going to apply. And then finally, if you go to the last page, my recommendation. The applicant has provided sufficient information for both conceptual and preliminary review by the Planning Commission. They have stated that they're on a strict timeline and claim that this is necessary. Therefore, staff recommends that the Planning Commission ensure that the applicant understands the expectations that they are placing on themselves prior to allowing them to proceed. And if all are in agreement, then staff supports allowing the applicant to move forward. And that's all we have.
Thank you, Brian. Any questions for staff? Any questions? Well, let's hear from the applicant. And please state your name and address.
And if you like, I can sign. So my name is Gary Nusinoff. I am the applicant. This is Thomas Klassen, business partner for about the past 8 years. And
the last name is Klassen?
Klassen.
Klassen. Okay.
And I'll sign.
We'll sign. And Judith Davis. So This is technically Thomas's cannabis license that he won in the lottery. I had one as well. I actually gave it back because we have always intended to work together. We've built a really good rapport. As we get into this, I will give the background. I could talk all night about this. We are happy to answer any questions. First, I do want to thank Brian and Dean. They've really communicated very well with me to help me with this project. We've been going strong for 2 years. We're able to raise the money, find this building all over like the past, say, 6 weeks and get it done. But we've effectively worked, the past decade on this type of project. Our background is in this industry. We have built a company that was the first Baltimore City cultivation company. It was the first tiered license in the state for medical cannabis with all 3 licenses. It was the first licensed CGMP edibles kitchen recognized by the state. And Judith as well helped open one of the first Baltimore City dispensaries. So, to say the least, it's an honor that we get to be here and do this. So we're happy there's a rule book. We're happy to follow rules. And that's why, when Dean and Brian had their suggestions for this fence, our answers were yes, yes, yes. So we've made sure to locate in an area that is acceptable. We just had the inspectors from the MCA come out today for our first preliminary inspection. They brought out a team of 6. So if you've ever had 6, random investigators and police come to your door, the way we finished with it was they basically said we're the most prepared people that they've spoken with yet. And that comes down to, our pride in our ability, how we want to work with the commission or, the local governors, so to speak. But we're here to do it right. And in that, we've said we are in a rush. It is an agricultural crop. And in speaking with the commission, they feel they can get us approved by spring so that we can plant and have our first outdoor crop this year. We have very little renovation in that we have the fence, which we have a drawing that we can, have you guys pass around real quick. And one thing that Brian did not mention is that we've offered plastic slats along the front of the road for a more, a nicer looking fence besides just privacy cloth. So if you all tonight said, hey, pick this color, this is the color of Cambridge, we're putting that color on our fence and happy to do so. So if we were to leave tomorrow and say, hey, fence guys, we can work through this, they're ready to install in February. We have our walls engineered. We're ready to, if you guys say go forward, we're ready to submit that to you all. They're temporary partition walls, nothing structural. We have an electrical upgrade. The electric's already there. It is making the sockets that are there be the right sockets. So the people that we've worked with have all worked with other cannabis licensees to get it done. So they are aware of both the MCA guidelines as well as Cambridge, zoning, permitting, so on and so forth. So ultimately, today we're here to ask and beg for, approval to change the zoning for a cannabis use. It is zoned correctly, but now we need the word cannabis in there. As well as, work with us through our certificate of occupancy as, we work with planning and permitting to get this done expeditiously. We've put a couple things in there that we would do. Tom can talk a little bit to the landscape plan. We're happy to beautify the building. We come from plant backgrounds. Judith from financial and compliance and high level industry. So we are the people to make this thing nice, and we like beautiful places. talk about the landscape plan. We had that extra fence change to draw the offsets that Brian was talking about. And again, let me give you our fence estimate real quick, and you can kind of see what the gate might look like, and we can, like I said, pick out some colors. But basically, we do have a fence and a gate going across the loading dock, so we have secure load in and load out of products, as well as secure storage of our cannabis dumpsters, but also per the guidelines in this plan. The building does have bicycle parking already, just while I'm thinking about it. We can show you a picture of it, but we know you'll be out to inspect it. We're not doing anything with it. But, you know, we're happy to really just answer any questions anybody might have about our plans, our future plans, you know, what we're doing now, timeline. Any questions? Or you want Tom to talk about the landscape plan?
I mean, is there anything that is part of the plan that, well, let me ask it a different way. Are you in agreement with staff, and is there any, so we don't need to hear it again. I mean, are you going to do what the staff has asked you to do?
100%.
Yeah, so I don't need to hear it if anybody.
One question, it really doesn't relate too much to the use, but how many employees do you feel you'll end up with at this facility?
In the end,
What's the end? 2-3 years from now.
So 2-3 years from now, we probably will have to apply for some more parking. So we don't envision that we'll get over the 20 people within the first 2 years. And then we'll have, the intention is to take the field and slowly build out greenhouses over the years. So we will have more staff and we'll be back again. This is how we get our business started efficiently and, you know, in the spring.
We're only building out a portion of the existing warehouse.
And do me a favor, just put your name on the record.
Yeah.
So
No, you don't need to write it down, just tell us.
Oh, sure. Thomas Clausen.
Right, thank you.
So is it now easier to get financing than when all this stuff started with banks and no, it's not easy?
It's easier with banks. Money and financing for the operations investment side is much more challenging.
So because we're pre-revenue, a bank, even though Shore will work with us, they won't work with us until we have revenue. There's tons of high money lenders. They still want us to be a millionaire to lend us the money. And this could sound like it has ego, but we're very well known as like fantastic people in this industry, like from a compliance perspective. Even we took a very long time to really raise just the most minimal amount of money to get it done. We have politics, we have drugs, we have all of the things in between. And so this was a right size thing for us, and you know, we made what we could raise work.
Right. So you'll have no problem doing what you've depicted on the plan in terms of the build out, in terms of what's required.
For what it's worth, it is a couple $1 million. It's not $50,000.
I got you.
I have a question.
Yeah.
Actually, I have a couple of questions. I guess I didn't realize you were doing greenhouses, so you're adding some impervious surface. Now, I assume.
Not for a couple of years.
Okay,
Yeah.
but someday you will have more runoff on that site. Now, I think the stormwater management for that site is all predetermined. I know you got some big ditches and stuff.
It's pretty
and other outlets. And
Yeah.
so I'm just trying to get this on the record that you may have to address that if need be. Okay, that's
And
one.
there is an exception for agriculture,
Yeah.
which we are determined by the state to be agriculture. We have agricultural exemptions on certain purchases.
Sure.
But absolutely, I'm a certified nutrient management plan writer. We'll have a nutrient management plan with the state as required. Anything we have to do, it's totally fine.
Okay, well, good. I'm glad to hear that because that goes to
It's
my
on
next
the record.
question. So this goes to my next question. The smell. how are you dealing with that? I've talked to a local architect who does a lot of this kind of stuff, and he says it's not a problem anymore. But I'll tell you, we have a problem in this city with the smell of the Coulter grow facility over there behind the food line. Everybody gets contact highs over there. Maybe I shouldn't say it. Anyway, it's a problem. So how are you going to handle that?
So, there is not a condition that we have to meet. That being said, we were located within about 30 feet of residential homes when we were in the city. It was like wall of the building, alley, home. So we had a system, and it's probably exactly what Tim said, if Tim was talking to you about this. Which is helpful and not helpful in some respects. But there's basically a system that's like a giant Febreze system. And it encapsulates the smell. It's difficult. It's an outdoor agricultural product. We can't determine where the wind goes. Most of these companies have not purposely put up smell protection for the past 7 years. So now that they have to, most of their problems will disappear. But you could expect that one person out there is like, well, I don't like the smell of this Febreze. So, we try to work as best we can with the neighbors and use the technologies available.
Okay, so you are going to, you're going to use the best technology.
Yeah.
Okay.
We're going to try.
Okay.
Indoors, when it's a point source that you can control the exhaust,
Right.
it's much easier. Outdoors, a little harder. When we have the greenhouse, a little easier. Though it will be similar to Coulter's greenhouse in that the walls and the ceiling will open up. So it's not creating a completely impervious area. During the summer, if it rains, we could close it, or we could leave it open and the rain would just water the plants.
Okay, I'm fine, that's good.
And, any other questions?
No.
Commissioner
Uh,
Nasty?
So I have just a few. So just in sequencing, the first stage will that be inside the building or will it be outdoor planting?
It will be both. It will be
Inside the existing building?
Inside the existing building on the side where you saw the 2 demising walls drawn in the package. So it'll basically create 2 areas on that side. And then for the growing, our intention is to basically try and fill out this square. Whether we're going to accomplish that this spring to be determined, but that is the intention to build it further.
And then eventually, you'll come before us probably with the greenhouse addition. In this first phase, do you anticipate, I understand you said no more than 20 staff within the first 2 years. How about outside public or vendors or traffic, or how do you disperse the product?
There's no sales from our building.
Okay.
There are no pickups from our building. We are a deliverer. So, and that's part of Comar. Unless we hired like a third-party delivery company, but we're not doing that. We control our product from the cradle to the grave.
Okay.
Cradle to sale.
And then if you wouldn't mind, I'd love to hear just a brief overview of your landscape plan.
Sure. Yeah, so I have a small drawing, which you can show. It basically is that the front fence line with some drawn-in circles. Small evergreen tree line, staggered, and I had called out Magnolia virginiana and some Ilex opaca, highlights for that. And then a shorter shrub, mixed planting in front of that. Reference the Maryland, I think it's MDE, has some guidelines for native hedge plantings like that. These are all native species being planted and kind of predominantly evergreen, certainly over that 50% threshold.
Okay, and then
so it would just be kind of in that front section along the road that Brian referenced. Just some. So that's the fence line. It would be offset from the fence. We would have plantings right up against the fence because you keep the exterior of the fence a little bit clear for access.
okay, and then
And our video surveillance that has to.
okay, And then, in the first couple years, what kind of square footage are we talking? We're gonna be asked all of this by the public. Within the building and then outside, what kind of square foot are we talking about growing?
So the limit of the license, now this is not what we're doing, but I just want to give you the balance. The limit of our license is up to 300,000 square feet of indoor flowering canopy, or up to a 4-to-1 in outdoor, so about 27 acres. So that's what we are allowed to do. What we are going to do is roughly 3 acres of outdoor and roughly 5,500 square feet of indoor.
And that's in phase 1 for the first 2 years?
Yes.
Okay, thank you.
That outdoor space isn't gonna change, that's the full.
That's all you got, right?
That's all we have. Indoor will approximately double, perhaps up to, what?
Yeah, up to about 18,000 feet in total. And that turns into a 3-tiered system. So there's 6,000 square feet of floor space. It's 3 levels in that same floor.
Pallet racking,
Oh,
basically.
that's interesting.
And does that count against the square footage?
It does,
Okay.
it does, yeah.
So the 6,000, that gets you up to the ultimate 18,000 in interior, okay? And no more than the 3 acres outdoor,
Correct.
okay?
It's until we measured, it's about maybe 3.1-ish, but yeah.
Okay, good, thank you. And just with reference to the fencing, I thought that the tan or the gray
Oh, yeah.
seemed a little more subtle than having the bright colors.
I was thinking the hunter green.
Well, there's a blue like in the seal.
Oh, yeah, that would pop.
I was trying to remember the color of the building. There's existing color on the building, right?
It's like there's earth tones like brown, I think is the.
So you gotta consider that.
For the actual warehouse.
It's if you guys said, hey, this is it, I mean, we'll probably come back at some point and say, hey, we want to paint something, also mural on our building, as soon as we get some cash to be able to do that. But, we like a good looking place to work and basically live the majority of our lives.
Right.
So
My only last question, does staff have any, it sounds as if you have no ongoing concerns here?
No, I mean, we've had quite a bit of communication, and I think they've addressed everything that we were concerned about. The main thing was the landscaping, which you addressed, Mary, and I think they've addressed that sufficiently, so we're okay with everything.
Good, thank you. Thank you.
Mr. Stanley, any questions?
No, fine.
Do you still operate the Baltimore place?
No, so
We were workers.
yeah, we were like some of the first employees in this whole industry. It was the whole promise of vesting, and it didn't happen. So we looked for all our alternatives.
Mm-hmm.
I was a VP. These guys are both directors for like the whole time. We literally built the company, and then we said, let's go apply to the lottery.
And so this will be your first project after that?
This will be our first project after that.
Yeah, okay.
We basically resigned on the day we won.
Mm-hmm.
No conflicts, clean slate. Let's go do it new.
Yeah.
But if you like Evermore, no, we still love you.
Just one last question, if I may. In that lottery, was it a substantive or is it truly a lottery?
It was
like
run by the Maryland Lottery.
Oh, okay, so it had nothing to do with your background or criteria.
We had to apply and meet certain qualifications in our application. We were drawn from a pool of, I think it was 72 in the eastern region.
Well, congratulations.
Thank you.
One other question, so this is strictly medical, right? So are they're differentiating now?
No, it's actually all the same.
Okay.
So we can sell our product to the dispensary. The dispensary says no tax to a medical patient and higher potency, or tax to the adult use patient and regulated potency.
Okay.
So for us, we still produce by the same standards, but the whole state is considered adult use now.
Yeah, that's what
It's not called medical cannabis per se.
As I recall, the first grow and processing facility, I don't know if when it started off, I guess, as medical at first, but you could actually trace this back to a plant ultimately. Is that still the
Oh,
case?
We have 187 pages of rules to
Okay.
let everybody know where it comes from. Everything's tested third party. If you went and bought a seed, I mean, we were the first to make seeds in the market. Like, if you went and tested, or bought that, we could tell you exactly what plant and what crop it had been produced from.
How about that?
Every plant that we grow, small plants, big plants, every plant in the field has its own unique RFID tag. So when we're inspected by the state, they come in with a scanner and they say, okay, in room 1, you're supposed to have 500 plants. These are the 500 plants. I'm missing 5. Find them for me.
Yeah. Well, it seems that compared to a lot of other states, Maryland actually did this pretty well. Even though it's highly regulated, it is for the public's benefit. And you hear a lot of horror stories in other states that didn't do that. So it's great that you're investing in the community.
And as well as that, it was on Brian's write-up that we sent him. We're also allowing our employees to do community service as well, paid from us. We believe in giving back. I mean, honestly, we're fortunate. We literally won the lottery, and then had people invest in us. So
That's great.
So,
I said I wouldn't cry, so I can't keep going.
I just had a quick question. Is Colta considered a dispensary or just a grow?
They are a 3-tiered license, so they have a grow. I think they have 2 dispensaries and a processor.
But here it's just a grow.
Yeah,
It's just a grow here.
Yeah.
Just a grow here.
Just a grow here.
I didn't know if they were within 2,500 feet.
It's separate zoning, so we're only zoned for cultivation and processing at that location. Dispensing is a totally separate zoning category that has a lot of restrictions.
Yeah, okay.
But is your question about having 2 cultivation areas
Well, the
within
code seemed to
proximity?
be you couldn't be within 2,500 feet of a dispensary.
Oh.
Yes.
No.
Dispensaries have to be 2,500 feet separate from each other.
Oh, okay.
But the grow is, the only condition was 1,000 feet from the school.
Got it, okay. Yeah.
And you will do the
See, I
cultivating
thought
and
about
processing
Colta, too,
in that
but I
facility?
was like,
So we're only going to be cultivating to start.
Okay.
When we find a processor to co-locate with us, by MCA state law, as long as we follow certain rules, they can co-locate with us. Of course, we would probably be back here with you guys again as we're going through permitting and stuff like that. That's why we wanted to make it say cultivation and processing instead of just cultivation at this time. Condition being the same.
So I have a question for Brian and Dean. So they're asking for preliminary, actually, hang on, conceptual and preliminary. You're suggesting that they've already met that standard.
Yeah, I feel like
in order to get that, so there's not much left to do for final, right?
right. So then, then everything gets submitted to the staff, and we have to go over everything. And George and myself and Dean and like 3 other people.
Well, where I'm going with this is, thinking about our motion, do we approve concept and preliminary with a caveat or with the condition that you take care of final and doesn't have to come back to us? We do that on occasion, depending on the level of compliance that we've got here. Is that?
Yeah, I don't think it needs to come back to you all, to be honest with you, but
Well, that's what I'm trying to get out on the table here, is where are we with this,
Yeah, I think we did that with a previous application
Yeah.
for a subdivision review over by the Hyatt.
Right, we did.
We did a
Oh,
combined,
yeah.
and I think the motion just referred to the approval of the preliminary.
Right. So exactly. My point is, this is just my opinion, not speaking for the commission, but I don't think I need to see this again.
Oh.
I second that.
We would really appreciate that. I kind of let Brian know, you don't know us from a hole in the wall, but we cannot operate without the MCA coming in and very tightly regulating us and looking at everything we've done. They need the documents from Brian. Brian's not going to give them to me or us if we've done something wrong.
So, if we're ready, are we ready for a
Oh,
motion?
I was going to say, any final comments before we make a motion? Nope, ready for a motion.
So I'd make the motion that we approve concept and preliminary plan with the condition that the applicants work out final details with staff for final approval and occupancy and so on and so forth.
I'd second that.
Right, all in favor?
Aye.
All opposed? The ayes have it. Motion.
Congratulations.
Congratulations.
Welcome.
Thank you all so much.
Welcome.
This is amazing.
Yep, welcome.
Yeah.
Thank you. Yeah, we'll be back. Will you run to anything?
Bring samples.
That's hilarious.
So let's just say there was someone at every meeting we find, the world has changed, the stigma has changed. It's better to have a regulated product, and
Yeah,
those who want to participate have a safer alternative.
That's
Thank you for believing us. If you do, it's great to hear.
All right. I'm gonna make a new number. We added a couple things to the agenda. One was the Hearn building and the adjacent building and getting an update on that. I think that, Mr. Craig, that was your addition. Who would give the update? Who are we looking to? Staff? Okay.
Yeah. Do you want to do it, Dean? Yeah.
All right.
Yeah, the two additions were for staff.
Yep.
Yeah.
Sure.
Thank you, everybody.
Bye-bye.
Safe travels. Thank you.
So which one do you want the update for first? 611?
No, let's do the Hearn building first.
Her building
Yep.
first? So the developer, who's under contract with NCAL property owner, requested an informal review with the HPC. This is done without an application. They're just giving, basically it's a status update. They're giving us a peek behind at their map, basically. And so they provided a fair amount of data, including some correspondence and partially executed memorandum of agreement with the Maryland Historic Trust and the state agency managing the LTAC development, the LTAC portion, so low-income housing element, and indicating that their current plan, based upon their current map, met with Maryland Historic Trust's approval and with the housing work, and they were still working with the housing authority to make sure that their numbers met the expectations. The HPC's questions were more about engineering veracity, and because as it turns out, much of the stabilization work that had been done on the interior of the building, of the Hearn building, not the 505 building, because there had been a 507 which was lost. But at the Hearn building, it was just enough work to keep the walls from crumbling. The interior steel work that was put, it's a shell of a building. The interior steel work was not sufficient to support any new floor loads. It was just enough there to support the roof that was going to make that shell mostly weather tight. One of the interesting pieces of information was the geotechnical report that had been produced back in 2022 that showed that the actual soil bearing capacity, the load bearing capacity of the soil, was only 1,000 pounds per square foot. And to put that into reference, if you're building a light gauge wood framed residence, a single story home, your per square foot load bearing capacity for soil is 1,500 pounds per square foot. So essentially the building is just in a very, very fragile state. There's been significant loss of the brick, the vitreous surface of the brick on the interior, and while it is possible, this is kind of paraphrase what the developer is conveyed in that informal review, while it's certainly possible to go in and suspend the entire brick facades of the side and the rear facades and under excavate, bring in structural fill, and then rebuild the entire foundation, it would be extraordinarily expensive to do so. So what they had been penciling out was to take the existing side and rear facades for the current building and take them down and rebuild stable within the same footprint. Completely preserve the front facade, so that, and it would be restored and would meet the 40-foot deep non-residential use, so there would be commercial use back. And that but the 505 building was already in, according to their engineer, who had been the engineer even during the stabilization process that the city had engaged in a number of years back. The 505 building is already beginning to rack, and in their opinion, it's not salvageable. But whether it's salvageable versus whether it's appropriate for historic preservation are two separate questions. So what Green Street was proposing, what they proposed to Maryland Historic Trust, which they tentatively said we're okay with, is if that 505 building comes down and they build a new building in the same footprint to basically kind of replicate to some extent what that 505 building had been. And where the 507 building had been, plus the 8 feet on either side, because there had been these little 8-foot wide alleys on either side, that would remain a driveway and parking area and then access to some parking in the back. What that would have provided was 34 units in the Hearn building footprint and 10 units in the 505. So for a total of 44 low-income housing units. The Historic Preservation Commission expressed concern over the loss of the historic fabric, meaning, well, what about the 507? Because that had almost been a continuous street frontage. And Green Street's response was they felt that they had always been obligated to only stay within the existing building footprints, and they couldn't go out beyond it. They weren't entitled to do anything where the 507 had been. And the HBC's response was, if you're asking us for an informal review, we would like to see the restoration of the street frontage. And we would think that you might be open to something like that because it gives you a potentially larger building footprint where you could build more units and potentially generate more revenue. And the city could then expect to have some sort of benefits improvements along the street frontage. So improve sidewalks, improve pedestrian crossings, improve street landscaping, etc. And that was the nature of the conversation. So the Green Street left, their architect was in the room, and they went back and put pen to pencil, or pencil to paper, to kind of come up with what might be an interesting concept that they would bring back as part of a formal application with the HBC. The city council took it on the following Monday. I think city council had expressed concern about the potential loss of the side and rear walls of the Hearn building and the loss of the 505. And they reiterated via resolution, the support for adaptive reuse, historic preservation, and adaptive reuse. The city manager and staff also recommended, and I believe historic preservation, at least the chair of the historic preservation is open to the idea of the city retaining an independent engineer to assess the veracity of the assertions that were made by the engineer that's under contract with Green Street. There's reason to believe that there wouldn't be any different interpretation, given that that's the same engineer that has been involved in the project since the very beginning. And in fact, the senior staff, Maryland Historic Trust, had actually been very involved in the conservation to date of the Hearn building. So that's kind of where we're at right now. I believe as of yesterday, I think Green Street is going to come back and give an actual status update to City Council this coming up Monday. And that's because at that resolution, there really wasn't a public comment period. Although Green Street was here, there wasn't a chance for them to present much. And the packet that had gone as part of the informal review, the HPC, wasn't presented to the council either. Or to City Council either. This was just the express will of the council. So that's, in a nutshell, that's where we're at. We're continuing to work with Green Street and look forward to seeing an actual application, and hope to see some work being done soon on the 500 block.
Well, I agree with that, but we approved a plan.
We sure do.
And now you're talking about a different plan.
Yeah.
You have to come back to us.
It would all start over.
Absolutely.
Yeah, okay.
Yeah.
I mean, we were told that other building was not salvageable. That's what they said.
That's what they're saying.
Plain and simple.
Yeah.
That's what
The
they're
507 or the 505?
505. We never addressed 507 because it was never brought up.
Yeah.
They like the open space there, I guess.
Well, the city demolished 507.
But that was a long time ago.
So
Right.
2013, I believe.
I can't remember if it fell or if we demolished it, but
It first caught on fire. It first caught on fire. It was.
Yeah.
This is a classic demolition by neglect story.
Yeah.
And
You're right.
so, what can we do as a public partner to repurpose this, to salvage what's there and what can be done? And there's a whole bunch of opportunities that could happen, a whole range of different things. Some of which are, right out of the playbook for standard historic preservation. Others maybe a little bit more innovative. You've seen some sketches. They're not even worth discussing at this point because they quickly just sat down with somebody at CAD and drew it up. And we said, well, we want to have a conversation with you about that. And I think we're going to try to do that at staff later this week. We want to have a conversation with Green Street before they make a presentation to council. Because
well, they are coming in on this Monday to present to council, so it's on the agenda. So they'll be presenting, but everything that Dean said is also happening sort of behind the scenes. So.
Well, thank you, Dean. That was very thorough.
Yeah, that was great. Thank you.
I'll give you some additional insight. Number one, I worked with Eastern Shore Land Conservancy and their Center for Small Towns, or Smart Growth, to try to save 507 Ray Street. We were going to keep the facade and brace it, but City Council had a meeting here to vote on it, and they gave everybody 3 minutes, and they voted to demolish it completely. So I've been working with Katie Parks for 6 months. It was very frustrating, and boom, this one meeting, they voted to just demolish the facade. So I think we've come a little way further in terms of historic preservation and leadership in our city. MHT is getting totally politically beaten up on this. It's embarrassing that they just caved on the historic need to preserve the envelopes of these buildings. I think it's totally DHCD coming down hard on MHT, who's part of the division of Department of Planning. But that's just my interpretation and my read of things. I've worked with Jeremy Walbert. He's with Becker Morgan, who was the engineer before when it was Stanley Kaiser, and he got retained by Green Street. I find it funny because I've used him on 444 Ray Street, which essentially had a fire with high heat, and we determined we could save those walls, historic brick walls, and we are rebuilding within that envelope. And so I said this in the media tonight, if you push a structural engineer, if you pay them, they'll tell you what you want to hear. And so I find it interesting that Green Street's paying these guys now and they're bringing up issues like per square foot weight loads and things of that nature. I think if you could find another structural engineer that can tell you that both buildings could be saved. And so that was our kind of, some of our arguments without having all the facts yet from Green Street. We basically said we support Green Street, but we'd like to see them work within the envelope of the building. You know, the fact that they may not be able to get enough units or more, they want more units or whatever, they should have to work within the envelope and retain the historic fabric. So anyway, that was kind of, we got accused of maybe jumping the gun. Brian Roach presented the resolution, but I thought it was good to get out there and make a statement.
You know, and of course, as it all sits here, costs must be going up from even when we approved the site plan, and I don't know how long the low-income housing tax credits that were awarded to it stay there, which they said they couldn't do any of that without the low-income housing tax credits. So
they're good on those still. I'm pretty sure.
But it's got to be 20% more expensive than when.
Yeah, definitely.
Yeah, certainly.
Right on down since they got awarded. I mean, I think construction costs probably peaked in 21, 22.
Yeah.
And, you know, now it's gotten back to a more stable.
Yeah.
And I will say, if anyone wants to know about the status of the Hearn building, they should hear Kevin Hill with Hill Kimmel Contracting testify. He and Matt Hill know that building better than anyone else. They're the ones that got the roof on it and did all that steel work, and anybody else is just speculating. So I just make that recommendation.
So it'll be back.
Well, then it'll be back in front of us.
Okay, what about the next one?
611.
Thank you.
Thank you.
That one's easy.
Thank you.
That was easy. We met the following day with the attorney, and we kind of reviewed it. I think the discrepancy, it was, from my perspective, was there are like two separate portions of the code that talk about non-conforming uses and what can happen.
Yeah,
and you pointed out that there is this clause within a sentence that says single-family uses do not require variance or deviation. So we said, yeah, that's what the code says. So we immediately got on the horn to both the owner of 611 and her realtor, and also another applicant who was also going through the same thing, that had a non-conforming residential lot.
Good.
And we were able to refund their application fees and allow them to move forward. In fact, the owner of 611 Hubert has entered into a discussion with a contractor who wants to purchase the property, except his standard, the one design that he owns is 26 feet wide, but the building envelope is only 25 feet wide.
Yeah, you got to stick with that.
He's got to stick with, because if he wanted to get that deviation to the side yard setbacks, he would have to go before the Board of Zoning Appeals. And he goes, okay, I think I'm just going to cut a foot out of. I go, okay.
That's the way to do
You're
it.
going to have a 1 foot narrower bathroom and a 1 foot narrower bedroom and a 1 foot shorter kitchen. So that's the update on that.
Great.
Thank
But
you.
what it's done is it's reaffirmed our commitment to getting the Unified Development Code revised. Because what we've seen is administrative sections are scattered throughout the code as opposed to consolidated in a single location.
Yeah.
And administrative procedure process questions are scattered throughout the code. And it can happen. I'm surprised that a code that's only was adopted in, I think, 2018, that it's in its current state. That's usually evidence that code has been around for about 20 or 30 years, and it gets patched along the way, and you see these kind of internal discrepancies or disconnections.
Yeah.
But this is the chance, and that's why it's so important to get the comprehensive plan adopted, and it builds the policy framework for code revision. Because there can't be anything in your UDC for which there is not policy support in the comprehensive plan. And right now, there's a bunch that's in the UDC, of which there's no mention in the current comprehensive plan.
Well, hopefully we can fix that.
And the same consultant did that. I mean, we participated, but still.
Yeah.
Yeah, and we do appreciate the working teams
Yep.
that are looking at the various sections.
Well, I think in the first few years, we were having revisions to the UDC constantly
Yeah, Pat was doing it.
because there were either errors or inconsistencies
Oh, my gosh.
in it. Yeah.
I think Pat was trying to do the right thing, but it's like really hard when you fix one thing, but then there's another section here that refers to.
Well, the comp plan was done by a previous planning director, basically. And,
Yeah, you're right.
And then Pat Escher came in. And, yeah, so there was some stuff mixed up in there, you know, because I agree with you, it's difficult. When I was reading through that as a land surveyor, I've worked all over the state, and a lot of record is a lot of record. It's got rights, you know. You can't change the size of a lot by a zoning ordinance.
Right.
I mean, you can change the size of new lots, but existing lots you can't change.
Yeah,
That's where I was coming from, but I understand your point about
Yeah,
that.
you create legal non-conforming
Exactly.
conditions.
Right.
And we just dealt with an issue today where we had a non-conforming use and a letter, a zoning determination letter was issued to the property owner. The city was under the impression that more than 90 days had passed, and therefore the bridge back to the legal status had lapsed, except that property owner was in a nursing home at the time and has since passed away. And they have successfully gone through 2 rounds of rental registries as a multifamily use, but there's still a letter saying that 90 days had lapsed and it couldn't be used as a multifamily. And the unfortunately, that individual died in testing.
Wow.
So the court it's in a probate status, and that attorney who's managing the estate has had to go back and provide evidence and sworn testimony from a renter that was living there during that 90-day period. And with that, we were able to say, if that owner had been aware, he would have been able to provide that evidence, and therefore that letter issued in 2022 is null and void. But these are the types of administrative headaches that we honestly shouldn't happen, but sometimes it's just inevitable. It happens.
Yeah, they happen. Yeah.
All right, citizen input? I don't think so. Any final staff comments?
Nope.
Any final commission
My
comments?
wife wants me home.
Yeah.
I'll have a quick chair comment. I appreciate, the confidence. Very humbling. And I'll tell the staff, we may not always agree, but you guys do a hell of a job. You work hard, and I appreciate it. So thank you very much, and I look forward to working with you. And on that note, do we have a motion to adjourn?
Motion to adjourn.
I second it.
All right, all in favor?
Aye.
So moved.
All right. Congratulations.